Hi everyone, you're watching The Caffeinated Corporate Lawyer, where we try to make meaningful content to help you better understand the intricacies of corporate law. I hope you guys are doing absolutely fine and are adequately caffeinated, because today we are going to discuss Section 8 of the Companies Act 2013, which deals with formation of companies with charitable objects. These companies which are incorporated for pursuing charitable objects are known as Section 8 companies, or as we popularly know them as non-profit organizations. A well-renowned Section 8 company is Reliance Foundation, which was founded by Mr. Mukesh Ambani, and it is affiliated with Reliance Industries Limited. It is one of the largest profit-making foundations and was formerly known as Dhirubhai Ambani Foundation. Its main objective is to promote sustainable growth in India, and it is actively involved in diverse sectors such as rural transformation, promoting education, health, etc. Other famous examples of Section 8 companies include Federation of Indian Chambers of Commerce and Industry and Confederation of Indian Industries. The objective of these companies is to facilitate the growth of trade and commerce in India. The main objective behind the incorporation of Section 8 company is to promote the welfare of the society. So, without further ado, let's begin with Section 8. Section 8 Subsection 1 basically talks about who can apply for registration of a Section 8 company. Any person or an association of persons intending to register a limited liability company for objectives as specified in Clause A can opt to apply for registration of a Section 8 company, and they may be given a license to operate as a Section 8 company by the central government, subject to fulfillment of the conditions as enumerated in Clause A, B, and C of Subsection 1 of Section 8. They become eligible to obtain a license to operate as a Section 8 company if the three requirements which are given under these three clauses are fulfilled to the satisfaction of the central government. Clause A states that such a proposed company should be incorporated with the objective of promoting charitable objects such as commerce, art, science, sports, etc. Note that this is not an exhaustive list, and a Section 8 company can be incorporated for any other charitable object as well, subject to the approval of the central government. Secondly, such a proposed company should intend to apply its profits or other income in promoting its objectives as enumerated in Clause B. That is, it should use the profit made by it in furtherance of such objects. And lastly, such a proposed company should intend to prohibit the payment of any dividends to its members as stated in Clause C. If all these three requirements are met, then such a proposed company can be incorporated as a limited company, subject to other conditions which may be imposed by the central government. Therefore, it is clear from this that such a person or association of persons would be given the license to operate only if the central government is satisfied to the extent that the said proposed company is in compliance with all the three requirements as stated in the three clauses, as well as any other conditions that may be applicable on it. Once accepted, the registrar of companies will register the company after the applicants pay all requisite fees. It is important to note that such companies can only be limited companies. Further, these companies also do not need to include the words limited or private limited in their names, as all other companies have to. For instance, as we saw above the example of Reliance Foundation. Now, Section 8 Subsection 2 states that the company registered under this section shall enjoy all the privileges and be subject to all the obligations of limited companies. This means that all privileges and obligations of limited companies are applicable to a Section 8 company. Section 8 Subsection 3 further states that a firm may be a member of the company registered under this section. This is an important point to note. We know that any person or association of persons can apply for incorporation of a Section 8 company. But what is meant by the term person? The term person is not defined anywhere in the Companies Act 2013, but is defined in the General Clauses Act 1897. Section 2 Clause 41 of the General Clauses Act 1897 states that a person shall include any company or association or body of individuals, whether incorporated or not. Therefore, such a person can be a natural person or a legal person. However, if we see Subsection 3, it states that even a partnership firm can be a member of Section 8 company. This is a distinguishing feature of a Section 8 company, that even a partnership firm can become its member. Here's a small exercise for you guys. Tell us in the comment section if a partnership firm can hold shares in a company and who can become shareholders of a company. Another important point to note over here is that the central government has delegated its powers and functions to the ROC. It is the ROC which will have the power to grant the license under Subsection 1 of Section 8. If we click on Central Government, we will be redirected to this notification of MCA dated 21st May 2014, which states that the central government has delegated its powers onto the ROC with respect to subsection 1, clause 1 of subsection 4, and with respect to subsection 5 as well. Thus, registrar of companies of respective jurisdictions are delegated with the powers of the central government to issue license to Section 8 companies. Here's a quick question for you guys. Can a company with unlimited liabilities be registered as a Section 8 company? Why or why not? Hit us up in the comment section with your answers. Moving on to subsection 4 of Section 8, which says, a company registered under this section shall not alter the provisions of its memorandum or articles except with the previous approval of the central government. A company registered under this section may convert itself into company of any other kind only after complying with such conditions as may be prescribed. This essentially means that a Section 8 company can alter the provisions of its memorandum or articles by passing a special resolution. However, such alteration requires the approval of the ROC as per the MCA notification which we discussed above. Further, if such alteration in the memorandum or the articles results in the conversion of Section 8 company to any other kind of company, then prior approval of the central government is required, which has delegated the said power to the regional director, again with reference to the MCA notification that we discussed above. Another pertinent point to note here is that Section 8 company cannot be converted into a one-person company. Now, let's take a quick look at the MCA notification. So if you scroll down, here it says that the central government has delegated the power to the regional director. We had discussed the concept of ROC and regional director in our previous video. So if you have any doubts about it, you can click on the link above. Now, if we click on as may be prescribed, we would be directed to Rule 21 of Companies Incorporation Rules 2014, and we can see the conditions which have to be met for conversion of a company registered under this section into a company of any other kind. We are not getting into the details as it mainly highlights the procedure which has to be followed. Now, moving on to subsection 5, the same point is being reiterated in subsection 5 as well, which we discussed while reading subsection 1. A person or an association of persons can make an application to the ROC using requisite forms to form a company with charitable objects. The central government, if satisfied, can accept such an application upon any terms and conditions imposed under the license granted by it. Once accepted, the ROC will register the company and all the provisions of this section would be applicable to it. Moving on to subsection 6, which essentially talks about the situations in which the license given to the limited liability company to operate as a Section 8 company can be cancelled or revoked. So, what are the grounds on which the said license can be revoked is given under subsection 6, which are A. If the company contravenes any of the requirements as given under Section 8, or B. If the company violates any terms and conditions of the license, or C. If it is discovered that the affairs of the company are conducted fraudulently or in a manner which is in violation of the objects of the company or is prejudicial to the public interest. In any of the above cases, the central government may direct the defaulting company to convert its status and change its name accordingly to add limited or private limited as the case may be. However, before any such action is taken by the central government, reasonable opportunity of being heard should be given to the company. This is what is given in the first proviso. Second proviso states that a copy of every such order should be given to the ROC as well. Subsection 7 states that where a license is revoked under subsection 6, the central government may, by order, if it is satisfied that it is essential in the public interest, direct that company be wound up under this act or amalgamated with another company registered under this section, provided that no such order shall be made unless the company is given a reasonable opportunity of being heard. Subsection 7 basically lays down the consequences of contravening Section 8 of the Companies Act 2013. It states that where a license is revoked under subsection 6, the central government can order for the amalgamation of the defaulting company with a company with similar objects, or can even order for the winding up of the defaulting company if it is satisfied that it is essential in the public interest to do so. The proviso to this subsection states that no order can be passed by the central government without giving a reasonable opportunity of being heard to the defaulting company. Now, Section 8 of Subsection 8 states that where a license is revoked under Subsection 6 and where the central government is satisfied that it is essential in the public interest that the company registered under this section should be amalgamated with another company registered under this section and having similar objects, then Notwithstanding anything to the contrary contained in this Act, the central government may, by order, provide for such amalgamation to form a single company with such constitution, properties, powers, rights, interest, authorities and privileges, and with such liabilities, duties and obligations as may be specified in the order. Subsection 8 further clarifies the point that the central government can pass an order for the amalgamation of the defaulting company with another Section 8 company having similar objects to form a single company, and what all decisions can be specified in such an order of the central government. Moving on to subsection 9, which states that if on the winding up or dissolution of a company registered under this section, there remains, after the satisfaction of its debts and liabilities, any asset, they may be transferred to another company registered under this section and having similar objects, subject to such conditions as the tribunal may impose, or may be sold and proceeds thereof credited to Insolvency and Bankruptcy Fund, formed under section 224 of the Insolvency and Bankruptcy Code 2016. This essentially states that in the event a winding up order is passed to wind up the defaulting company, and where pursuant to the winding up process, if at all, any residue assets of such a company is left even after the satisfaction of the debts and liabilities, then such surplus assets may be transferred to another company registered under this section having similar objects, subject to such conditions as the tribunal may impose, or such residue assets may be sold and proceeds thereof could be credited to a fund which was created under the Insolvency and Bankruptcy Code 2016 called the Insolvency and Bankruptcy Fund. So keeping in alignment with the goals of this section, which is primarily aimed towards pursuit of charitable objects and welfare of society, any surplus assets left over pursuant to winding up of such a defaulting company have to be utilized in furtherance of the same objects, which is why either it would be transferred to another Section 8 company or to the Insolvency and Bankruptcy Fund. This fund is formed under Section 224 of Insolvency and Bankruptcy Code 2016. Section 8 subsection 10 states that a company registered under this section shall amalgamate only with another company registered under this section and having similar objects. As we have discussed earlier, this subsection again lays emphasis on the point that the defaulting company can only be ordered to amalgamate with another company registered under this section and having similar objects. Lastly, Subsection 11 of Section 8 prescribes the penalty if any of the provisions of Section 8 are contravened. It states that if a company makes any default in complying with any of the requirements laid down in this section, the company shall, without prejudice to any other action under the provisions of this section, be punishable with fine, which shall not be less than 10 lakh rupees, but which may extend to 1 crore rupees, and the directors and every officer of the company who is in default shall be punishable with imprisonment for a term which may extend to 3 years, or with fine which shall not be less than 25,000 rupees, but which may extend to 25 lakh rupees, or with both. Provided that when it is proved that the affairs of the company were conducted fraudulently, every officer in default shall be liable for action under Section 447. So, if any company defaults in complying with any of the requirements as laid down in this section, then the company would be punished with a fine which should not be less than rupees 10 lakhs and which may extend to rupees 1 crore. Besides this, the directors of the company as well as every officer of the company who was in default would also be punished with imprisonment for a term which may extend to 3 years, or with fine which should not be less than 25,000 rupees and which can extend to 25 lakh rupees, or with both. The proviso to this subsection further states that if it is discovered that the affairs of the company were conducted fraudulently, then every officer in default would also be liable for action under Section 447, which is the penalty section for fraud. Here's a quick question for you guys. Can a foreign company be registered as a Section 8 company? Or if it would be eligible to become a Section 8 company, why or why not? Something for you guys to ponder about. Another small exercise for all our subscribers, why don't you guys send us a small write-up on Section 447 of the Companies Act 2013, which deals with penalty for fraud. You can send it to us on our Gmail ID, which is thecaffeinatedcorporatelawyer@gmail.com. That's all from this video. Hit us up in the comment section if you have any queries, or write to us at thecaffeinatedcorporatelawyer@gmail.com to give us your feedback. Follow our Instagram page to get some more exciting content, and don't forget to hit the subscribe button if you want to study all the sections with us. We will see you guys in the next one. Thanks.